Hello, magandang gabi po. Pasensya na po yung nag-live ako kanina, naiwanan ko lang po. I thought all the while na tama yung setup at nagreklamo po yung karamihan na mas malakas pa daw yung ingay sa likod kaysa yung salita ni Kaufman. But nevertheless, this time ay babawi po ako at ipalabas ko po ngayon yung buong presentasyon ni Attorney Kaufman at magbibigay tayo ng comment in its way. Ang pinaka buod po ng ating presentasyon ay dito po na ipakita ng depensa ni Digong Duterte na si Attorney Kaufman na ang ginawa pala ng mga umaakusa sa kanya na mga prosecutor, lalo na yung mga media sa Pilipinas, na ginamit ng mga ebidensya ang kanilang mga TV splices, ginamit na ebidensya dito sa ICC. Ang nangyari po ay nagpipresenta sila, nagamit sila ng ebidensya doon sa prosecutor at ginamit ng prosecutor ng ICC ang ebidensya ng mga video na kung saan nagmumura si Digong. Nagmumura si Digong, ipapatay nyo lahat yan. Pero ang problema sa kanila, yung dulo ng video ay hindi na pinresenta. Kasi naglagay ang dulo po, pagkatapos na pagsabi ni Digong na nagmumura sa mga pulis, patayin nyo sila. Kaya doon sa dulo. Pero kailangan, huwag kayong pumatay kung ang buhay ninyo ay hindi na sa delikado. Yan ang sinabi sa mga pulis. So lahat yung dugtong sa dulo ng mga video ay lahat doon ay tinanggal ng prosecution. At sinisisi ni Attorney Kaufman ang media sa Pilipinas na mahilig sila magninira kay Digong Duterte sa pamamagitan ng pagpakita ng bahagi ng video na kung saan nagmumura si Digong Duterte at inuutosan mga pulis para patayin. Pero yung karugtong ng video na kung saan na nagwa-warning din si Digong sa mga pulis, huwag kayong pumatay kung hindi nagdidelikado ang inyong buhay. Yan po ang buod ng pandaraya ng ginagawa ng mga media sa Pilipinas na lahat ay galit kalos kay Digong. Na ang mga media na yan ay kakutsaba ng mga makakaliwa. Kakutsaba nila Attorney Conti, kakutsaba nila ni Attorney Joel Butuyan, ni Attorney Gabriel Andres. Lahat-lahat na sila, kakutsaba nila. Lahat sila po ay galit kay Digong. Kaya ang pinipresenta sa media, sa YouTube, sa lahat ng mga video kuno ni Duterte na nag-speaks, na nagsasalita, ay pinakita lamang yung bahagi ng video, ulitin ko lang, bahagi ng video na kung saan ay nagsasalita si Digong na patayin nyo. Pero hindi pala sinama ang karugtong ng video na kung saan ay nagsasabi si Digong, do not do it. Do it only kung nanganganib ang inyong buhay. Okay? So, presenta natin po sa ngayon si Attorney Kaufman at makinig po tayo sa kanya. Ladies and gentlemen, ito na po si Attorney Kaufman at ating ipasok po. Ito pa. Sa every now and then, i-off ko yung video at magko-comment ako. So ito na po.
For the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, Associate Trial Lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masita. Ms. Masita, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman, good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Okay, pakinggan natin si Attorney
Now,
Kaufman.
before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade your honors that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of its case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists
Binira ni Kaufman
and
ng
their editors
local
have a
media
tendency
ng Pilipinas.
to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a...
So, bago mag-proceed, dais ko lang idiin na ang sinabi dito ni Kaufman ay, number one, ang kanilang depensa ay hindi po nagtutukoy sa paninira sa mga pamilya ng biktima ng war on drugs, kundi sa mga sinabi na panluloko ng prosecution. Ang panluloko na ginawa ng prosecution dito ay yung mga video na pinresenta sa media, sa ABS-CBN, sa Billionaire News Channel, sa GMA, ang mga media po na pinapakita, mga video po na pinapakita nila sa balita ay para ikakasama ni Digong Duterte sa mga nanonood sa TV at sa YouTube at sa Facebook. Kasi bakit? Ang pinapakita lang nila ang bahagi ng media kung saan nagsasabi nagmumura si Digong. Utang ina nyo, patayin nyo yung lahat yan. Lahat gano'n, patay, kill. Pero, hindi pala sinama ng mga media sa Pilipinas ang karugtong ng bahagi ng karugtong ng video na yun na nagsasabi at huwag kayong pumatay ng abuso kung hindi man lang nanganganib ang inyong buhay. Ganun po kaklaro ang sinabi ni Digong Duterte. Kaya ito po ang depensa ng abogado ni Digong Duterte. Ulitin ko lang, ang totoong buod ng depensa ni Digong Duterte, yung mga video na pinakita na ebidensya laban kay Digong kung saan ay parang inamin niya na siya pumatay, ay hindi pinakita yung kabuuan ng video. na kung saan sa dulo ng video ay nagsasalita si Digong Duterte sa mga pulis na pwede kayong pumatay kung nanganganib ang inyong buhay. Something to that effect ang nangyari. So maganda po mga Sir Ben Huerto, pagpatuloy po natin.
Selection of these speeches
Selection.
and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges.
So ibig sabihin, kinikriticize niya ang mga prosecution dito na pinipili lamang nila ang bahagi ng video na ipresenta para makumbinsi nila yung mga judges ng pretrial chamber na i-confirm ang mga akusasyon laban kay Digong Duterte.
But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense.
So ito, bago patuloy, sinasabi ni Kaufman na yung prosecutor, ang ginawa nila ay nagpresenta lamang ng mga clips ng video na sa 10 clips ang pinalabas at pinili lamang nila yung mga clips na kung saan ay hindi nila sinama yung bahagi na kung saan ay ini-exhort ni Digong Duterte ang mga pulis na sumunod sa batas. Tinanggal nila yun sa video. Kaya sa 20 na video na sinasabi ng prosecution na ebidensya na lalaban kay Digong ay lumalabas ng 10 lamang ang pinresenta nila. At sa 10 pinresenta ng prosecution ay gusto nilang kumbinsin ang pretrial chamber mga judges na dapat itutuloy ang kaso at lilitisin ang buong-buo si Digong Duterte. Pero ang katotohanan, nilabas ni Kaufman na yung mga video na pinresenta nila ay sa dulo nun may karugtong na kung saan yung nagsasabi na binabalaan ni Digong Duterte ang mga pulis na pumatay lamang kayo kung nanganganib ang inyong buhay. At saka, iba pa, pinangakuan binindong na pag gumawa, mag-abuso kayo, your life will go to hell. Yan po ang tinago ng mga prosecution. Kaya sa media din, tinukoy niya rin ang local media sa Pilipinas na sinasadya ng local media na gano'n para magalit ang tao kay Digong Duterte. So pakinggan po natin. So maayong gabi kay Cesar Hugar, maayong gabi sa imo dira sa Tacorong. Si Juben Rio, dalain na huni mo, tama po ang huni ko Juben para sa katarungan. Ayaw ko po sa tunog ng kasinungalingan. Yan ang katotohanan na Juben Rio. Romel Bingson, naimbang grabe, Dr. Tirador. At twisted, yon twisted. Tama ang correct term. Ngayon ko lang nakuha, twisted. Twisted po mga videos. O pagpatuloy natin.
Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG. So I have to believe the story of the police, for simply, they are my subordinates, and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, But if there is no peaceful method of doing it and you're presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL-OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath
Grabe.
the allegedly incriminating element.
Pinisinta lang sa media yung salita na nakakapsama kay Digong. Tapos yung karugtong na salita niya sa the same video, the same occasion na kung saan ay nagtatalumpati si Digong Duterte ay itinago ng media, hindi pinisinta sa TV.
He said, just do it right. We have our trainings that you can only kill if your life is in danger.
Oh, klaro. Sinabi ni Digong yan. Sinabi na you can only kill if your life is in danger.
And you are there performing the duty of a law enforcer. That's about it.
Yan,
Now
sample.
I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech, which the prosecution either missed or ignored because it doesn't suit its case.
Sinadyang ignored.
And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today.
Love you.
Make no mistake about it. I repeat again for all and for everybody's consumption.
Nakalive yun.
Do not kill if you are not in danger of losing your
Oh,
life."
klaro. Do not
Well,
kill.
it goes on. You can see it there on the screen.
Grabing ebidensya ni Kaufman. Wala na, panalo na si Digong.
Well, of course, the prosecution knows that we are going to
Kasi
argue
doon malabas. Doon
That's-
malabas.
many of these
Ang
speeches, in fact, the
pinisinta sa
majority of
media,
these speeches, I would say,
yung statement na Digong,
contain
puta na
this
patay niyo,
exhortation to the lawful
Ang
use of
video,
self-defense.
agarot mo sa video,
And
huwag kayo
learned
pamatay
counsel,
kung hindi
Mr.
na-
Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel
been
concept
twisted.
of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colorful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument, because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth. And that does not help the case for the prosecution at all.
Galing ni Kaufman.
Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here, I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions.
Conflicted. Invento lang
To
ang
start by reference to the widespread or systematic nature of the attack, I would like to draw your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers.
Okay, ito ang sinabi niya. Ni Kaufman, nagmamayabang sila na marami doon namatay sa Davao City. At yung maraming namatay ay kung tutuusin mo, kung huhukayin mong lahat yan, huhukayin mong buong Davao City para makita mo yung mga namatay. Yan po ang kwento nila. Pero anong ginawa nila? Nang binigay nila ang kanilang mga datos, mga detalye, mga namatay, ay yung pinili lamang nila ay yung mga nakuha ni Leila de Lima sa ginawa ng Commission on Human Rights at wala nang iba. Akalain mo. Tapos, hindi natin alam. Nanduloko pa nga si Kaufman dito. Hindi natin alam. Ay mga buto, yun na mga Hapon na namatay nung Second World War.
The same goes for another witness's outlandish assertion that bodies were
Yung mga buto rin pinakita niyo, buto pa ng mga Hapon na namatay nung World War II.
thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced.
So, wala pa silang...
As for count,
Ibig sabihin, sinasabi ni Kaufman na kahit isa doon sa mga sinasabi na mga bangkay na namatay kuno, ay wala man lang isa na ipakita ang prosecution. Kaya, nga sabi niya kanina, siguro yung mga naipakita na kinuha ng dating Commission on Human Rights Chairman na si Leila de Lima, yun lamang ang ginamit lang pinakita. Pero hindi natin na-identify, yun ba yung mga buto na mga Hapon na namatay noong Second World War? Oh.
counts 2 and 3.
Kita mo si Judge, oh? Judge Mutok, oh? Grabe, nakinig na husto si Judge Mutok.
Ms. Croft showed us some maps with colored dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case, masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report, which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages.
Ayan, detalye por detalye
So,
yan.
if I may just conclude, the only thing that is widespread here, or
So,
rather spread wide,
lumalabas sa depensa ni Kaufman, lumalabas na 97% sa drug war, sa war on drugs sa Digong, 97% ang inaristo na buhay. 3% lamang ang patay. So ano gusto yun? Anong ibig
the
sabihin?
utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pretrial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pretrial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025.
July 10.
The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purpose of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pretrial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals.
So, ibig sabihin, pinakita po, ina-argue ni Attorney Kaufman na yung kiniklaim ng prosecution na nag-attack si Duterte against a massive population ay dapat ipapakita ng mga prosecutor na identified ang grupo na inaatake ni Duterte. Nang ibig sabihin lang ko, para magiging masama yung pagpapatay ng tao, naglalagay ka ng pagkakilanlan kung sino-sino ang atakihin. Pero lumalabas po sa nangyayari, ang mga pinapatay ay paiba-iba, random. Hindi mo masasabi na puro Ilonggo, puro Cebuano, puro mga Ilocano, puro mga Bicolano. Hindi po ganun ang nangyayari. Random po ang nangyayari. Kaya sabi ang argumento ni Attorney Kaufman, para mo masabi na yun ay atake against a group of civilians, dapat ipakita na hindi random ang nangyari, kundi massive na plano sa lahat ng grupo na ipatayin.
So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders.
Kaya, sabi ng argumento ni Kaufman, dapat ipakita ng atake ay naka-atake sa lahat ng populasyon o di kaya sa grupo ng populasyon na well-identified.
The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly. Even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards.
Tingnan mong reaksyon nila ni attorney yung mga Filipino attorneys at saka kasama nila sa mga prosecution, para natulala sila sa sinasabi ni Attorney Kaufman. Mukhang tatalab ito. Ang una niya proposition ay number 1, 97% ng mga Filipino population ay hindi naman lang nagalaw. Number 2, ibig sabihin, ano yan, 3%? Pinili ba yun? O random? Number 2 ay napakita niya na napakarami ang mga hinuli sa panahon ni Digong na hindi man lang pinatay. So ibig sabihin, pag tiningnan mo yan, yan pong ebidensya na wala talagang utos si Digong na pumatay lahat ng addict sa ng mga tulak. Ang katotohanan ay presenta nilang statistics ng Philippine operation at nakikita na napakarami, 197,000 ang nahuli. Ang nahuli na buhay, ang nahuli sa drugs na buhay. So, ibig sabihin, ang argumento niya, paano nyo sasabihin na pumapatay si Digong basta adik at tulak, kung maraming nahuli na adik at tulak na 197,000 ayon sa records ng ating paghuhuli ng Philippine National Police at saka PDEA. So ang ganda ng argumento ni Kaufman.
With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after
So sinabi
Rodrigo?
niya, ano ba buang ba si Rodrigo Duterte na i-anonsyo niya kung sino papatayin niya? Yun ang sinabi dito. So talagang hindi ka pa paniwala. Ngayon, to educate you po, ay Benmar Huerte, wala na pong pagkakataon ng prosecutor na magpresenta ng pangkontra sa depensa. Kasi ito lang po ang proseso. Magpresenta ang prosecutor at tapos gaganti ang depensa. Tapos ito, magdidesisyon na ang pretrial chamber kung talagang may kaso o wala. Ganun po ang sitwasyon.
Duterte pulled his country out of the International Criminal Court. After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop.
So yan ha, pinupintat na ngayon ni Atty. Kaufman, bakit kung may ebidensya kayo, parang gano'n ibig sabihin, na hindi man lang ninyo nagawa sa loob ng panahon na bago mag-expire ang 1 year na withdrawal period ng Philippines. At saka, may binisto pa niya na mayroon pala ng authorization na mag-interview si Atty. Karim Khan, na prosecutor na ngayon, na mag-interview sa isang biktima. Ba't hindi na nagawa? So yan ang mga sekreto na ngayon lamang natin nalalaman.
I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred. And so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims.
So yan, sa lagi kong pinopoint out, sa lagi kong vlog, tangga, lagi kong pinopoint out sa aking vlog, na dapat magpakita kayo kahit sino mga pinatay para makita mong koneksyon ni Digong Duterte sa pagpapatay. Hindi man, dapat ipakita ninyo ang ebidensya na mayroong mga taong pinatay na si Digong mismo na supervise magpatay. So walang koneksyon. Yan ang argumento ni Kaufman.
That would have been the classical way to prove a causal link between
So
stuff
walang causal link, walang koneksyon.
that came out of Rodrigo
O
Duterte's
walang koneksyon kay Duterte tungkol papunta doon sa taong pumatay.
Mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b.
So,
But
yan,
the prosecution
yan
cannot
ang resulta
show
ng $2 million.
such a causal link. They've never been able to do that.
Gusto ko lang sabihin, yan na po alangga ang resulta. Kulang-kulang ebidensya pero pinagpapatuloy. Yan na po ang resulta ng $2 million na binigay ni Trillanes sa mga ICC prosecutor.
They show you a lovely pyramid. It's on the screen with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and a hitman.
Yan, pinakita ni Kaufman yung drawing ng prosecutor na sinasabi ang systematic features daw ng DDS operations. Si Rodrigo Duterte sa itaas, sa baba niyang other co-perpetrators, at sa baba nila mga DDS handlers, at sa baba yung mga hitmen. O, tingnan natin.
Perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope.
So, wala silang pinakitang koneksyon sa gitna ni Digong at saka yung co-perpetrator. Walang ebidensyang pinakita ang prosecutor. Yan ang sinasabi ni Kaufman.
Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the Pyramid of Giza. The most they can do is allege that they're cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte
49 incident na patayan langga. Wala man lang sila kahit isang testigo na na-produce.
is charged will testify that he received a direct order from the former president to go out and kill someone.
Wala sila na-present sa 49 incidents na magsasabi na nag-utos si Duterte sa 49 incidents na utusan ang pumatay, go out and kill.
Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince.
Tingnan mo yung mga prosecutor, oh, parang mga basang sisiyo, parang parang natabunan nabuhusan ng malamig na yelo.
Any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration. to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole.
Wala na.
And where
Talo na,
these
Prosecutor.
documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters I would respectfully submit are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability leveled at Rodrigo Duterte.
Ay, patay na.
As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous. And
Walang ebidensya na nag-exist ang common plan. Preposterous ang term ni Kaufman.
I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive, of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators.
Okay.
And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses.
Yun na natin ito. Interviewee. Ang ginawa na, no? At least more or less 10 by bus operation, sir. Interviewer 1. Where somebody shot? Interviewer, yes, sir. Interviewer 1. Okay, and on those 10 occasions, was the shooting justified? Interviewer, yes, sir. Oh, yan. Sige pa.
Interviewee, at least more or less than 10 by-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee. Yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't.
Okay, ha? So, i-clear natin ito. Yung interviewee na police, sinasabi, if he shoot at us, we would also shoot back. But if he were to stab us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. Okay?
We wouldn't shoot a person that was holding a knife.
Tulog na
And the
si
third
Judge
one.
Mutok.
Witnesses who said, the PNP never said kill those
Hello.
people. Another quote. From what I recall of the incidents that I was at, all of them had guns. And they were pointing them at the pusher buyers. Or they were pointing their guns at the pusher buyers.
Take a
The
seat.
operations I was at, I'm talking about the operations I was at. The reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication,
Makakatawa nangyari.
and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals.
Iba yung ibig sabihin ng neutralize. Ibang ibig sabihin ng to kill. Ginagamit na lang neutralize the board para ito pumatay. Anong klase? Oh, ano kayo, na-call out ang attention ninyo ni Attorney Kaufman.
That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties.
Oo, okay lang yan. Magbigyan mga baril, mga kwan. Kasi naalala ko sa presentasyon ng prosecution law, nagmamayabang sila sa mga judges. Grabe ito si Duterte. Noong nag-organize ng DDS, ay may party pa. Tapos, naglalagay sa mga isang basket ng mga baril. Pinaikot ang basket, pinapili ang mga DDS daw ng baril. Mamili ka ng baril nyo. Parang, sabi na Atty. Kaufman, walang masama para sa mga civilian volunteers na mamili ng baril.
That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it.
Okay, patunayan ninyo kung talagang sinasabi nyo na ito'y illegal, patunayan nyo. Yun ang sinasabi ni Kaufman sa mga prosecutor. Tamimi, parang nahiya sa sarili si Attorney Gilbert Andres at si Attorney Joel Butoya, nakayuko.
One does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible.
To neutralize, hindi. Ano ka ba? Produkto ng $2 million? Grabe.
Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
Naputol ba tayo? Naputol ba tayo? Tingnan natin kung ano. Lagi nilang pinuputol kapag si Kaufman pala nagsasalita, Ay, si Marcos naman may gawa nito ng paraan, Para hindi mapakinggan ng Pilipino ang mga argumento ni Kaufman, pinutol. Pero i-proceed natin,
criminal plan.
Talagang
And that is set
pinutol.
out in paragraph 27 and mentions that on the very day that the former president appointed Ronald De La Rosa, Bato, as the chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modeled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan.
So, sinabi lang ni Kaufman dito, inaamin niya na nagpalabas ng memorandum si Bato de la Rosa para i-anunsyo ang plan double barrel. At sinabi ni de la Rosa na ang pakay ay to neutralize. At yung neutralization, inargumento, kinontra sila ni Attorney Kaufman, hindi naman ibig sabihin na papatay ng mga adik o mga tulak. Ang ibig sabihin ng neutralization. Kundi, nung mas maaga pa, pinoint out ni Attorney Kaufman sa statistics na 197,000 ang lahat na inaresto na buhay naman lahat sa panahon ni Duterte. Ibig sabihin, pinapakita nilang na walang utos si Duterte na pumatay ng lahat ng ating katulak. Okay? At ang neutralization dito ay diniin ni Kaufman ay hindi ibig sabihin na pamamatay ng tao.
To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald de la Rosa, Bato, within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the
Ganoon ka
pre-confirmation.
mag-argumento, binabanggit mo kung saan ang ebidensya. Footnote 137, hindi ginagawa ni Attorney Joel Buto yan. Tsaka ni Attorney Andres Gabriel, ano po?
Brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question.
Bago patuloy, dinidiin ni Attorney Nicholas Kaufman na yung tukhang ay hindi masama, kundi taken out of context. Dito ipapakita niya, sa tingin ko ipapakita niya na napakarami ang kinatok, kinausap at marami ang nabubuhay at marami ang nakapasok sa rehab. Hindi naman namatay. So anong ibig sabihin niya? Tukhang pamamatay? Yon ang sinasabi niya. Pakinggan natin.
From the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights? Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL, OTP, 000
Yan ang tama. Nagsasite ng ebidensya kung saan ang galing yun.
In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Okay, nag-break siya. So, maraming salamat no sa kay Mariam Maliwat. Sabi niya, "Sir, watching from Houston, Texas. Nakatutok po mga amiga ko sa iyo. Check your views. Tumaas, 38 kami na nasa coffee shop. Maraming salamat sa inyo. Dagang salamat, damo nga salamat. Agyamanak sa inyong lahat. Mga Ilocano, mga Kapampangan, lahat-lahat. Maraming salamat sa inyo sa pagpanood." At tapos sabi naman ni Sam Dim, ang Oplan double barrel hindi naman nag-declare sa Supreme Court. Opo, may decision po sa Supreme Court ang Alanga na hindi bawal ang Oplan double barrel. At ang kanila lang problema ng prosecution ay pinipicture out nila na yung Oplan double barrel ay masama. At pinipicture out nila na yung salita na neutralize sa Oplan double barrel ay ibig din sabihin na pamamatay. So, asan ang kanilang logic? Ganun ang tanong. Ayan. Sabi ni Iner, si Iner Spider Ablaza, sabi niya kung hindi biased ang ICC, madismiss na yan 100% kasi wala ngang evidence. Very clear, walang evidence. Natumbok lahat ni Attorney Kaufman. Magaling na abogado sa Attorney Kaufman. At sabi naman ni Jojo, karon pa ko. Sabi naman ni Albert Cando, watching from Italy. Dok Toto, salamat po. Tapos Jojo, na-late ako dahil na-late ako si James Sundar, good evening sir. Sabi ni Jojo, good evening all. Tapos si Irish Shipo, watching from Lisbon, Portugal. O sabi ni Gilbert ni Boeing ni John Vic Remulla, nasa Lisbon, Portugal daw si Saldico. Hindi pala, nasa Stockholm, Sweden. Tapos sabi ni Tolitz, $2 million for ICC through Tiriling. So, Jenyap, kami rin attorney, sa'yo kami gusto sa live nyo. Po, salamat. Tapos sabi ni James Sonarlay, nasunog ang mga spliced na evidence ng mga prosecution. Halata, nakapakasama, no? Napahiya ako dati sa media, ako nang galing langga, kinisisi, pinakita ni Kaufman yung mga video na ginamit ng prosecution na kung saan nagmumura si Digong, putang ina, pamamatayin ko kayo. Yun ang ginamit ng prosecution. Pero pinresenta ni Kaufman, ito yung buong video. May karugtog na kung pamatay kayo, ay kayo, masisisi kayo, mapupunta kayo sa impyerno. Nag-warning na si Digong, you can only kill kung ang buhay nyo ay sa panganib. So sabi naman ni Katuto, sabi ni, sabi, nasunog daw ang splice. Sabi naman ni Andy, katuto, sabi ni Bad, tinambakan raw ng ebidensya si Digo. Ebidensya na walang kwenta. Sabi naman ni Arnel, Dr. To, si Inso, sabi niya, magaling daw prosecution. Mas magaling po sa kanya. Sabi, siya, dito kami sa Kuwait, nanood sa Doc. Salamat yung mga kababayan ko sa Kuwait. Sa Mike Force, ano pa sa tingin nyo? Malakas po ba ang mananalo? Sigurado po sa ganito, nakikita nyo na po. Tapos sabi ni Jane Yap, magaling ka magpaliwanag, attorney. Salamat po, naintindihan ninyo. Beautiful Earth. Sabi niya, watching from Singapore, napakatibay ng pag-deliver ni attorney Nicholas Kaufman. Magaling siya abogado po. At nakuha niya lahat ng depensa. Si Dario Arellano, sabi niya, more power, Dr. To. Jane Yap uli. Naintindihan talaga ang paghimay niyo po, attorney. Salamat po. Sa Joe naman, good sir. Watching from Ottawa, Canada. Wow, salamat yun sa mga taga Ottawa. Joe, good evening sir. Watching from Ottawa, Canada. Tapos sabi ni Jose Prosalejos, watching from Jeddah. Doc, salamat mga Pilipino sa Jeddah, Saudi Arabia. Yun, sabi naman ni Jojo, mao na diha, putol-putol, di ay ang video nila trililing. Yung putol-putol, pinutol-putol ang video, ipakita lagi kung saan nagmumura si Digong. Itago yung mga kasabay, yung naiwan, na nagsasabi Digong, puta kayo mga pulis kayo. Pag gumawa kayo ng kasalanan, ay sa impyerno kayo mapupunta. Sabi. Tapos, sabi naman ni Chris Ilagan, mao ako pang mas ako pang masabdan ang English ni Kaufman kaysa butuyan. Sama ka ng English ng Filipino lawyers. Malusot lang ni akong kimono sa screen. Mabakulan ni butuyan. Ay, maraming salamat Julia. Tapos sa iyong palipad, Duterte clan forever. Marcoses, Dilawan, hindi na nila kinadahunan si President. O nga, no? Maris Mabanag, wishing, asa na yung salamin ko? Ito pala, nasuot ako ng salamin, sandali lang. Si Maris Mabanag, watching from Cagayan de Oro, lagi ako nunod sa iyong vlog mo, sir. O, daghang salamat, Maris. Tapos si Raimundo Ribocas, delikado si Digong, mahina ang depensa. Ganon ba? Sobrang lakas ng depensa po. Ayos. Delikado si Digong, mahina. Hindi po yan delikado. Kerjak Obloroti. Ang may kasalanan po ang mga bias media natin dito sa Pinas, lalo ng ABS-CBN, GMA, TV5 at Rappler. Kasi pinasara ni Digong ang ABS-CBN kaya bias yan. Tapos Samdem, ang mga prosecution na ihi na sa kanilang karsunsilyo. Sabi ni Dennis Velasco, Attorney Toto, watching from Iceland. Dito kami mga tropa ko sa Starbucks. Wow, salamat paborito ko sa Starbucks yung kape latte. 11 kami nakikinig. Kami mamaya pag magpapalipad tropa ko. Salamat po papalipad ninyo. Sabi naman ni Miles Away Channel, Attorney Toto, off-cam magpa-interview. Sure ko yang si Conte. Okay. Aladdin Dael, Sir Toto, watching from Dammam, Saudi Arabia. Wow. Tapos si Joel Castronuevo, ang ganda ng argumento ni Kaufman, watching from Australia. Tapos si Cagayanos, good evening, Doc Toto, watching from Qatar. Wow. Jojo, dako kaayo, nakaulaw si ICC. Sa ICC. So Rodante del Rosario, watching from Abu Dhabi, Attorney Toto, maganda na manood sa iyo kasi pinagpaliwanag mo. Tapos mga Taiwanese pagkasulat, wala na katok attorney sa una pa lang kanya-kanya na pupunta mga user sa kada barangay para mag-exercise kay Hadlokman. Okay? Sino si Alizon? Lagot si Trillanes, mali ang binibigay na info sa mga prosecutors. Si Joe, hello sir. Ito bang $2 million galing kay Trililing? Nako, nawala ako Dali. Namatay ang ano ko. Namatay ang aking cellphone. Okay. Dito lang ako magbasa siguro, no? Okay, hindi ko na mabasa. Pasensya na kayo nawala ang salamin. Tika baka dito meron. Sa isang cellphone ko. So anyway, pasalamat na lang ako sa inyo. Hindi ako mabasa kasi mahina ang salamin ko. Maraming salamat. Babalik ako immediately after 15 minutes.